All right, and I'm going to turn it over now to our judges.
Good afternoon, Oregon. Congratulations on making it to national finals, and congratulations on making it to the last session of the second day. I know you want to get to the third day, but just take a moment and reflect that you've actually made it to the end of the second day. One more hearing to go. But I am Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, their neighboring state to the north. I'll let the other judges introduce themselves.
I am Edward Volpe. I'm an attorney from Denver, Colorado, and I've been working with this program for many years.
I'm Caitlin Johnston. I am an attorney in New York City, and I have been with this program for many years as well, all the way back to when I was in high school, when I did it as a student. So best of luck. Looking forward to hearing your presentation.
I'd ask the students to introduce yourselves and then also your teacher or coach.
Hi, we are Unit 5 from Grant High School in Portland, Oregon. My name is Ava Phillips.
I'm Talia Baskin.
I'm Zoe White.
I'm Makota Powers, and our teacher is Miss Dee Pasquale.
As you know, we are in Unit 5 and we're dealing with question number 2. I'm going to read the question, and then at the end, you'll have the opportunity to begin your presentations. In a letter to James Madison, Thomas Jefferson wrote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
It was the winter of 1787. Thomas Jefferson and James Madison were engaged in an intellectual discussion about their young country. They wanted to figure out how best to protect the newly won liberties of the United States from the types of abuses and violations that had become so common in England and its colonies, but disagreed on the best way to do so. We agree with Thomas Jefferson. An explicit Bill of Rights protects the liberties of every person and ensures that inference is not the basis for protecting fundamental rights. Jefferson and the Anti-Federalists believed it was important to be express and explicit about their essential rights, as stated in Federal Farmer 16. However, Madison and the Federalists believed that there was no need for an express Bill of Rights because the Constitution created a limited government, and that the act of listing specific rights would imply that it was the state and not the people that held sovereignty. Ultimately, the Anti-Federalists won, and a National Bill of Rights was created.
The most important advantage of a National Bill of Rights is that it serves as an elemental protection for citizens against the national government. The founders followed John Locke's social contract theory, which held that all people possess natural rights, but that the people must sacrifice some rights in order to protect life, liberty, and the pursuit of happiness. The Federal Bill of Rights protects every person and sets the floor of rights for the states. Over the course of history, the Supreme Court has used the federal Constitution to protect a wide range of rights. For instance, in Griswold v. Connecticut, the Supreme Court used the penumbra of the National Bill of Rights to define a right to privacy. Similarly, in Ramos v. Louisiana and Gideon v. Wainwright, the Supreme Court protected the rights of criminal defendants.
However, there are also benefits to state bills of rights. Because states reflect the views of a smaller and often more ideologically similar populations, the state bills of rights can guarantee and experiment with more rights. As Justice Brandeis wrote in New State Ice Company v. Liebman, the states work as a laboratory of democracy. For instance, Wyoming granted women the right to vote in 1869, which then led to many other states recognizing the same right, and then the 19th Amendment. Other examples include Oregon's expansive free speech clause, Oregon's death with dignity provision, and Florida's strongly worded education clause. A major tension in bills of rights is the balance of positive and negative rights. Positive rights are rights that place a duty on the government to provide a service to the people, such as education clauses in state constitutions. Many constitutions in other countries contain positive rights, which impose affirmative obligations on the government. In contrast, negative rights prevent the government from infringing on certain fundamental rights. All of the rights in the Bill of Rights are negative, including the Sixth Amendment's right to counsel.
We define liberty as the freedom to do what one wants without interfering with the same right in others. Because of this, negative rights are more important to the preservation of liberty because they restrain the government from acting against the people. However, true liberty comes from a mixture of negative and positive rights. In the United Nations Declaration of Rights, there are negative rights like freedom of speech, but also positive rights like education and vacation. Having only negative rights means the government has no obligation to provide help to people, even in very basic situations like housing or food. These services are important in the goal of achieving life, liberty, and the pursuit of happiness. As Nelson Mandela said, to deny people their human rights is to deny their humanity. Thank you. We're ready for your questions.
All right, thank you very much. I'd ask you to put aside any notes you may have, and we'll provide you the questions. What limits, if any, should be placed on individual rights that are listed in the Bill of Rights, such as freedom of speech?
I think that one limit that should be placed is on hate speech. Currently in the United States, we use the Brandenburg test as established in Brandenburg v. Ohio, which actually protects hate speech because it's not likely to incite violence in the court's eyes. In many European countries, there are hate speech limits. For example, in Germany, because of their history with the Nazis in World War II, they have imposed hate speech restrictions.
I would also argue that right now, a limit that is kind of important is the limit on the court's interpretation of religious, the freedom of religion, specifically in cases such as Tandon v. Newsom, where the court prioritized religious gatherings over the protection of from COVID-19.
I would agree with Ava, and I also think that another case to mention in regards to religion is Roman Catholic Diocese of Brooklyn, New York v. Cuomo. And I think in both the case that I mentioned and the one that Ava mentioned, the Supreme Court has been valuing religious freedom at a much higher level than the standard is that was set in Employment Division of Oregon v. Smith, that said that religious freedom is applicable to the generally applicable law standard. And I think as far as every right goes in the Bill of Rights, it's important to balance liberties and not let one get too out of proportion.
We have a problem with this right to religion being prioritized right now because but public health is not being prioritized, and public health should be a compelling government interest over the religious freedom in cases of this COVID-19 pandemic.
Do positive rights and negative rights occasionally come into conflict, such as an individual's duty to serve the common good? And I'm thinking in terms of the military draft.
I'd say for the military draft, there is some aspect of the positive right that you should sacrifice some of your own freedom so that other people have protection from certain threats that you would use the military to protect people from. But I think that you should have the option of being the one that decides whether you want to make that sacrifice, and it shouldn't be something that's mandatory as it is now.
I somewhat agree with that. I think that we don't have very many civic duties in our country. We only have civic duties such as paying taxes, obeying the law, and serving on a jury when summoned. And so I do think that in America, it would be beneficial to have more civic duties to preserve the common good of all.
I agree with Zoe, but as Justice Posner said, the Constitution is a charter of negative rather than positive liberties, and I think that the U.S. really prioritizes natural rights philosophy, whereas European countries where they have a lot of positive obligations through the UN Declaration of Human Rights kind of have a more classical republicanism view on rights.
So what circumstances, if any, can someone lose the rights that they are afforded under the Bill of Rights or elsewhere in the Constitution?
There are certain exceptions to many of the rights that we have in the Bill of Rights. For example, the Fourth Amendment, freedom from bad searches. There are many exceptions, such as if you're stopped, stop and frisk is an exception. Exigent circumstances is another. And so there are certain situations where the government has found that, for the purpose of the public good, you might not have that right.
Also, as we articulated in our direct and which is kind of from John Rawls theory, our definition of liberty is that you have as much liberty except when it infringes on rights of another. So I think that in cases such as Brandenburg v. Ohio, where the court established that if speech is likely to incite or produce imminent lawless action, it can be regulated. I think our country as a whole has kind of regulated our other rights in this way, whereas if they encroach on the rights of another, they can be regulated, but they can't be regulated under other circumstances.
But you've both just told me about limitations that maybe a court has placed on rights. Are there any circumstances where I can just lose them? Can I lose the right to freedom of speech? Not just in one circumstance, but
in order to lose a right, you have to go through, the court has to go through due process, which is mainly articulated in the Fifth and Sixth Amendments.
As well, there is something called the three-pronged stool of due process, which means that you have to be noticed of why you are being convicted. You have to have the opportunity to be heard by a neutral magistrate.
thank you.
What is the difference, if any, between rights that are added through the amendment process and those that are established by court decision?
Well, generally, it's very difficult to add rights through the amendment process. So the majority of the rights that are additional that we didn't have at the time of the founding have been added through court processes, such as substantive due process, which established the right to privacy in Griswold v. Connecticut. And the courts really got a lot more power after the decision in Marbury v. Madison, where they established judicial review. So I think that's where the majority of the new rights have come from.
I would say that legally they're the same. However, socially, rights that the court has found are more contentious. For example, Obergefell v. Hodges and Roe v. Wade are constantly up for debate, and many people think that they are wrongly decided. Whereas rights such as the First Amendment in the Bill of Rights are much stronger, and nobody really denies that they're there.
As well, rights that are passed through the legislature can be positive rights, whereas in America, it would be really hard to enact or amend our Constitution to add positive rights, because that would mean we would also have to amend Article 1, Section 8, and give Congress the power to regulate those positive rights.
Can state rights and federal rights conflict? In other words, can states declare something legal that is in fact a federal crime?
The federal rights kind of set the floor for what rights can be, but states can expand off of this. However, federal law is higher law than state law, so it kind of takes precedent in situations where two rights of state and federal government come into conflict.
Fine.
I'm sure you had a brilliant thought, but you're going to have to hold that. So, all right. Well, congratulations. I really appreciated the presentation. I appreciated the teamwork that you provided. You gave us some good examples of lots of different cases. You gave us your opinions about what you thought was more important in answering the questions. You brought in some of your own experiences through some Oregon statutes and Constitution, the death with dignity law that you talked about. So I really appreciated the presentation, and I'm going to turn it over to my fellow judges who are going to give you some more specifics, Mr. Volpe especially. So thank you.
I think you demonstrated a thorough understanding of this particular question with regard to positive and negative rights and the original philosophical basis for requiring such rights. You did refer to the United Nations Universal Declaration of Human Rights, and I thought that was good. It's hard to enforce that on an international basis. You did talk about the need to serve the common good, which we usually do through taxes. You're talking about housing and food and those kinds of things. And I thought that was a good response. I thought you did a good job on handling the draft question. One of you thought it should be optional. Unfortunately, it is not. But at the same time, it is the conflict between serving the common good at the expense of your individual rights. I suppose taxation could be the same thing. In other words, we pay taxes to support our government and to support our fellow citizens. Going on, then, I thought the reference to Wyoming's initial grant of vote to women was an excellent point with regard to state bills of rights. That's the first time I've heard that in the competition. I thought that was excellent. You also began to discuss penumbral rights, and certainly the court has the authority to recognize penumbral rights, and as they did in Griswold, in Obergefell, and similar Roe v. Wade, similar other cases of the kind. And those were basically an interpretation of the right to privacy as guaranteed under a number of the individual rights guaranteed in the Federal Bill of Rights. And so the court can conclude that by implication, some of the express rights can give rights to additional rights. And I thought you did a good job of getting to that point. I thought you did a good job of defining positive and negative rights. And you clearly have the opinion that we should have civic duties, and I thought that was excellent. And I thought you did a good job with referring to specific cases, going all the way back to Marbury in terms of the power of the court to declare what the right is. And you might have cited the the Sixth Amendment on the fact that the Constitution is the basic law of the land. It is the superior law of the land, as stated in Article 6. And so the whole question of whether or not state bills of rights can supersede and or interfere with the Constitution, it is clear under Article 6 that they cannot. Now, can they differ? Of course they can. And one example is marijuana. Some states legalize marijuana. Other states prohibit it. The federal government prohibits it. And so there is occasionally a clash between the two bills of rights. But getting back to your presentation today, I enjoyed it very much, and I think you demonstrated an excellent understanding. Good luck in the competition. Take this knowledge with you into the society that you are about to join. You know more than most of the American public. And I want you to use that knowledge in political involvement and in instructing your fellow citizens. Thank you for your hard work.
Thank you.
I don't have much to add after that. You all did wonderfully. I really enjoyed the conversation. You were very smart in your follow-ups about taking opportunities to show us what you know, both in answering the question that was presented, but then building off of each other or potentially going in different directions. When you were asked about limits on free speech, you moved it into limits on religion, and then took the opportunity to give us a policy view that demonstrates you had clearly been discussing these issues and had an educated perspective to share with us. And I like it's one thing to just give a flat opinion, but you brought cases in to back up your assertion, and you cleverly used a question that wasn't exactly on point to pivot your way in and show us what you know. So I thought that was very good. In my question, I was looking for, if you commit a crime, we will incarcerate you and we will take away certain rights because you've broken the social contract. And should you be allowed to vote if you've been convicted and served time as a felon? So, but you did a good job showing me a bunch of other stuff you knew about due process and restrictions on warrants. So again, I really commend you on your mastery of a very, very broad subject. So great job.
Thank you.
Thank you.
All right, that brings our hearing to its conclusion. I want to offer you guys a round of applause today on a very, very, very nice job